everyone, I'm Lavanya from Lexis and Company working as an intern today. I'll be talking about affidavits. Now what is an affidavit? Affidavit stands for a sworn statement which is made in writing and necessarily under an oath or affirmation before an authorized officer or the magistrate. A written promise is referred to as an affidavit and according to its latent roots, it is related to any other type of promise in English. Here, the provisions of CPC 1908 on the subject of affidavits are contained under section 139 of order of the what are the essential features of an affidavit. First, it must be in writing. It needs to be a declaration by the deponent. The facts mentioned in an affidavit must be true to the best of the knowledge of the deponent. In order to make it valid, it needs to be sworn in under an oath before an authorized officer or the magistrate. An affidavit is never made on behalf of some other person. Now, when are the affidavits used? First, in the cases of divorce. Second, property disputes, disputes about debt, confirmation or of received legal documents, name change verification, residential address verification, firstborn child certificate, and marriage registration. Now, who is authorized to draft an affidavit? Affidavits can be drafted by anyone. However, one has to fulfill some basic requirements in order to write an affidavit, such as an individual must be of legal age and fully understand the nature of its components. In other words, the person must not be insane or rendered unconscious. An affidavit that claims to have been made by a female declarant who has appeared before the court magistrate or other officers in question while wearing the veil is not valid until she has been properly identified. Now, what are the types of affidavits? First is the judicial affidavit, which are written on judicial paper and properly stamped with the court fees. The judicial affidavits must be submitted for a variety of reasons, including but not limited serving as a proof or as an application support. A judicial affidavit needs the oath commissioner's attestation to be considered valid. The non-judicial affidavits. Affidavits are not legally binding and are written on non-judicial stamp paper. In most cases, it is at least ₹10. The non-judicial affidavits are typically used in administrative or the business context. The attestation must be signed by the notary with both his seal and notary stamp, and it shall be entered in the notarial registration book.